About 2 months ago, a man in the neighborhood, let's call him Mr. X for the purposes of our discussion, severely assaulted a lady, let's call her Mrs. Y, very defiantly and in broad daylight with everybody watching, and severely injured Mrs. Y. To the point that looking at the nature of the injuries, one can safely say that Mrs. Y suffered severe and permanent injuries, almost maimed, if we could put it that way. And just because the incident happened in broad daylight, everybody watching, it was expected that he would be arrested and that he would be taken to police custody for a long period of time and maybe even convicted. People expected conviction and heavy punishment because they believed that the nature of the assault and the injuries sustained by Mrs. Y deserved the strictest punishment provided for in the statutes of the law. Now, after that incident had taken place, of course, the police came and arrested Mr. X, and took him to police custody. And then we understand that Mr. X was taken through the legal processes, and then, the charges were formally pressed against him at the local magistrate's court. And then everybody was expecting that Mr. Y would remain there indefinitely, or at least for a foreseeably long period of time before his return to the community. But paradoxically, about 2 days ago, he was seen walking downtown, a free man. And times are already working. People are asking themselves exactly what could have happened. How did Mr. X get to become a free man so quickly and so soon? And considering the fact that the incident happened with everybody watching, people are convinced that indeed there's no way he could have got got away without case, scot-free, without a successful prosecution. So as a result, people are speculating that maybe owing to police corruption or corruption within the justice system, the criminal justice system itself, talking of the prosecution department, or the Department of Prosecution, prosecutors themselves, or even the officers of the courts, the presiding officers such as the judges and the magistrates. People believe that because of that high prevalence of corruption, people are getting away with all kinds of murder and all kinds of, criminal activity, not facing the punishment as they ought to face it within the context of the law. But now I would like you and me to look at whether there could be any legal basis for what has happened. Is there any legal explanation for why Mr. X is seen walking around as a free man, even though people know exactly what he did and they are convinced that what he did was a wrongful and illegal act? Now, this brings us to a principle of law that I would like us to discuss. It is called the presumption of innocence, because I think a lot of us need to understand what we mean by presumption of innocence. What then do we mean by the principle of the presumption of innocence? It simply means that every person is regarded as innocent until properly convicted by a properly constituted and competent court of law. It is presumed that a person is competent until the contrary is proved in an open court. The accused person goes through a proper legal trial, which is conducted in compliance with the rules of criminal procedure. and the rules of the law of evidence, the principles of the law of evidence. So these rules are applied in the pre-trial phase, that is when they are arrested, as well as through the trial phase and even in the post-trial phase of the case. Remember principles such as when we talk about the pre-trial phase, you have a right to remain silent, and that is to protect the privilege against self-incrimination, and allowing the police maybe to just pull a fast one and cause you to make convictions, rather to make confessions prematurely without thinking about them. The trial process must not be tainted with partiality or any other forms of irregularities. I'm sure you will recall this famous statement by a British jurist who said, justice must not only be done, but it must be seen to be done. So we are saying in the case of, in conducting a proper trial, only admissible evidence is admitted in reaching that verdict or that conviction, whatever the verdict turns out to be. Taking into account that a conviction is an officially objective and impartial statement, it's a pronouncement made by the presiding officer of the court pursuant to a properly conducted trial, as we have already said, and in compliance with the principles of legality. In other words, those principles must really be taken into account. You can't just, drag people before a kangaroo tribunal and then make pronouncements and then, forgo the essential principles of procedural fairness, and then you just go on to convict them. That would just not be fine. That would not be fair, and nobody wants it done to them, so why should it be done on others? Considering that public opinion is a very unfair and unjust trier of fact, because the public only imputes factual or moral guilt upon a perpetrator of an act or conduct, but legal guilt is what counts, and legal guilt is based on objective law. It is based on objective view and consideration and assessment of whatever evidence is available. So usually when people accuse the police of corruption, and they assume that everybody who goes out of custody has done so on the basis of corruption, they are overlooking the fact that there are principles of objective law where it is only the legal guilt that counts, not all this guilt that comes from, that is passed by people, conviction that is passed by people who are not even objective in their analysis. So factual guilt is premised on subjective consideration, and it's not necessarily just. Sometimes people just draw conclusions prematurely. Taking into account also that the principles of substantive justice and the principles of procedural fairness should always and always and always take that primary position and play that significant role in the process of trying anybody accused of an offense. There are certain interests that are protected by the principle of the presumption of innocence. First and foremost, let's consider and remember that it is a basic facet of personal freedom. It is an onerous burden, heavy burden indeed, to compel citizens to prove that they are innocent. Imagine somebody asking you to prove that you are innocent. It just places a burden that is not really in line with public policy and just the interests of justice generally. So the idea is that he who makes an allegation that Mr. X has committed an offense must go ahead and prove that Mr. X has indeed committed that offense. Other than that, Mr. X remains a suspect, and on the day that he is taken to court, he becomes an accused. But he is still entitled to his freedom and his right to be presumed innocent. So, you see, because Mr. X is a full legal subject, he is not an object of inquiry. He is not stripped of all the rights available to legal subjects. So he is still a bearer of his own rights and duties as a human being and as a legal subject. Until the day that he is formally convicted, he will continue to enjoy all the rights and all the freedoms. So, but now to secure the attendance of the accused in court, that's when there is an infringement on their freedoms, hence the arrests. Remembering that primarily one of the reasons for the arrest is to secure the attendance of the accused to court. Other than that, the accused remains formally entitled to his freedom. He is still a free man or a free woman, whatever the case may be. So we are saying to protect the dignity of every person, they must be presumed innocent. It is unreasonable to call upon anyone to prove anything negative. Can you imagine being asked to prove that you are negative? Where do you even begin to make that proof that you are innocent? So you can't prove anything negative. But he who alleges must then go ahead and prove that you have indeed committed whatever offense you are being accused of having committed. So, taking also into account that the state or the prosecution is the bearer of the onus or the burden of proof. So the state is the one that alleges that a particular person has committed an offense. Therefore, the state must bring that proof, which is then weighed on the basis of this quantum of proof that we often say is proof beyond reasonable doubt. Of course, the quantum of proof in criminal trials differs from that in civil matters, where a preponderance of probabilities is acceptable as a quantum of proof. In the case of criminal law, or rather the criminal case, it is proof beyond reasonable doubt. The state of the prosecution must prove beyond reasonable doubt that Mr. X has indeed committed the offense he is being charged with. Other than that, Mr. X remains a free man as a matter of principle. Because remember, everyone is entitled to the protection of the law. So even though Mr. X may have done what he did, he still deserves and is still entitled to that protection of the law, as it were. So his rights will always have to be protected. Take into account that the perpetrator of an offense is not a criminal, but is just a suspect. I know, loosely speaking, people will begin to call Mr. X the criminal the moment he has been involved in whatever he may have been involved in. But at that point, he's not a criminal, he's a suspect. And when he's taken to court, he's still addressed as the accused. Take note of this. One of the principal justifications for upholding this principle of the presumption of innocence in law is that we need to prevent a wrongful conviction at all costs. Because a wrongful conviction is as unjust as the allowing a criminal to get out of the hook. There are two issues being balanced here. If we don't uphold the principles of procedural fairness and justice, we may end up with innocent people being wrongly convicted, even of offenses they have not committed. That would be very unjust and very unfair. But again, there's the issue of the risk of allowing or letting a criminal go scot-free just because we are pursuing this procedural and formal justice or formal fairness. which some people still find a bit out of step and a bit odd. But we have got to balance these two, because whilst it is as bad to convict, whilst it is bad to let a criminal go scot-free, it is equally bad to convict wrongfully a person who has not committed an offense. So in the scenario above, you notice that Mr. X has been tried in the court of public opinion and convicted in the court of public opinion, which is regrettably tainted with a lot of subjectivity and a lot of irrationality. Now, having said all this about the presumption of innocence, we now want to look at the principal elements that make up the presumption of innocence. What is it that it entails? Now, first and foremost, the state, as the bearer of the burden of proof, is the one that is saddled with the responsibility of proving that Mr. X has indeed committed an offense. But before we get to that stage, Mr. X remains an innocent man as a matter of principle. So you find therefore that Mr. X is entitled to bail. He may formally apply for bail, which is then considered by the court. Of course, the state will present arguments against the granting of bail to Mr. X. But once the court is satisfied that indeed Mr. X is going to attend the trial process, the court can then grant bail to the suspect so that he maintains his freedom. He will attend court at those times set for the hearing. And if he is finally convicted, then he will be sentenced maybe to custody, and then he will go into prison. But before there is any conviction secured, Mr. X remains an innocent man. So that then explains the principle of bail. He gets bail so that he can continue with his life, in case those that are just placing what you call an accusation upon him are actually misguided, because not all accusations are properly founded. Some of them are misguided, as in the case of Mr. X and Mrs. Y. We may not have all the full facts about what was transpiring. What if it so happens that Mrs. Y had threatened to shoot and kill Mr. X, and therefore all this assault that was being witnessed was maybe an exercise in self-defense? So these are some of the issues that Mr. X may bring before the court later on in the course of the trial. So in the meantime, before we get him to explain what was happening, he is presumed to be innocent. Therefore, he is entitled to his freedom. And as a result, when he applies for bail, it may be incumbent upon the court to grant him the bail, of course, on certain conditions. Now, whilst that is still, while the trial is still pending, Mr. X retains his right to remain silent. That is to prevent self-incrimination. And even in the course of the trial, Mr. X is not obliged to prove anything. He can remain he may remain silent in the course of the trial, and the court does not have to make any adverse inference from the silence. It's only that if at the end of the state case, the state has proved beyond reasonable doubt that Mr. X has done whatever, has committed the offense, that is, if the conduct being complained of meets all the definitional elements of the crime that is being charged with, if he does not say anything to gainsay or to contradict what the state has presented, then he may eventually be convicted. Taking into account that if the state case is weak in itself, Mr. X can actually apply for absolution from instance. That is, he may actually get the matter, the court to, pass a verdict of not guilty, even without him going into defense. Because if the state has not presented a strong case, a prima facie case, why should X be put to his defense? Because X doesn't prove anything. It doesn't have to prove anything as a matter of principle. He remains an innocent man or an innocent person, whatever the case may be. So that right to remain silent still accrues to him. It's still one of those rights that he can claim in the course of the trial. Taking into account, of course, that only admissible evidence must be taken into account in the trial, and any evidence obtained maybe in violation of the law or of the Constitution cannot be admitted and will not be admitted. And since innocent people should not be convicted, it is important, therefore, to uphold the principle of the presumption of innocence, so as to maintain the integrity of the criminal justice system and to engender that confidence in the system. You see, everybody must have that confidence that there is fairness within the system. So, as we have already said above, those who witnessed the arrest of Mr. X may have assumed that he was already guilty of an offense. But remember that an arrest doesn't always mean a conviction. In fact, doesn't mean a conviction at all. It is just a preliminary stage in the criminal justice process, just to secure the attendance of Mr. X to court, so that he may eventually face trial and all the facts and evidence may be presented to the court, so that then, after a proper trial before the competent court, properly constituted, then a conviction, or let's say a verdict, may then be issued, and then the judgment will be given, the sentence will be given if he's guilty of an offense. So those are matters matters to do with the presumption of innocence that must be upheld at all times. It is clear from what we have discussed above that not all persons who walk out of custody do so because of corruption. Some people are out because of bail. They are out on bail. They've gone through the proper process of the law and they have applied for bail, which has been granted to them formally. We have also noted that justice does not only entail the conviction of perpetrators of crime, but it also hinges on the procedural and the formal justice and fairness during trials. It is interesting that when we think of criminals, we think of them as people somewhere out there, and we are not we don't figure out that one day we might find ourselves standing accused of offenses. Some of the accusations which might be true or baseless and unfounded. And on that day, that's when we would want all this procedural justice and fairness to kick in. But I think if we are going to desire it at a time when we are in that scenario, we might as well indulge the rest of the people who find themselves accused of offenses. So we need to constantly remind one another that the objectives of the criminal justice system go beyond seeking convictions, much as they also include the need to establish the truth on exactly what transpired in a particular scenario. Remember that suspects and accused persons are not only people out there, we have already spoken about that, and we also come to realize that it is important for everyone to be treated with dignity. Even those who are accused of offenses, they still deserve that right. They still have that right to be treated with dignity and respect. Instead of treating them as objects of inquiry, we must remember that they are still bearers of subject. They are still legal subjects and they are bearers of rights. So those rights still subsist unto them, even though they may have been, even though they are suspected of committing offenses. That brings us to the end of our discussion. Thank you for watching our videos at iclassvirtual.co.za. Remember to subscribe and click like, so that we may always update you on all our other videos as they come out. Thank you. Enjoy your day.